Good afternoon, everyone. Hello, and welcome to today's webinar, Frequently Asked Questions on ECQ and GCQ. I am Mayan Cometa, your host for today's webinar. Thank you for taking time out and being here today. We are actually live on Facebook and YouTube also. As we all know, the enhanced community quarantine is now being implemented on selected places which are considered high-risk areas. Low-risk to moderate-risk areas were placed under general community quarantine, including the rest of the country. Due to the enhanced community quarantine, the government ordered the closure of almost all private establishments, save those that are exempted but only allowed to operate by skeleton workforce. GSMH law, in our interest to keep our clients abreast of the legal updates, sent a legal memorandum on this with the attached government issuances on COVID-19. GSMH law thought that there may be some other ways to keep you updated, hence this webinar. This webinar is actually a brainchild of GSMH Law's partners, including our managing partner, Attorney Jerome de Guzman. Attorney de Guzman is one of the founding partners of GSMH Law. He specializes, among others, in corporate law, intellectual property, admiralty law, and contract enforcement. Attorney de Guzman is actually here today to have his opening remarks. Attorney de Guzman?
Okay, thank you, Mayan. Good afternoon, everyone. Thank you for joining us in today's webinar. This is the third webinar for GSMH Law. We hope that by now, you already have a mastery in video conferencing. Indeed, this will be a new way to conduct business in the months ahead. Should you like to view GSMH Law's other webinars, our team will instruct you later in the presentation. For today's program, we will tackle the frequently asked questions during the enhanced community quarantine and the upcoming general community quarantine. Hence, today's session discusses mainly your FAQs during the ECQ and GCQ. Now, since the start of the ECQ, government has issued numerous circulars and guidelines for businesses. However, the transition from ECQ to GCQ is about to be implemented. As we make this transition, I am sure that we are all concerned with the safety of everyone working in our respective offices, facilities, and sites. But we must nonetheless find a way for our businesses to remain productive under this new normal. Sadly, many of our clients in business no longer see 2020 as a profitable year. Several of them believe that the main goal for 2020 and until the first half of 2021 is simply to survive. But while the coming months look challenging, businessmen are still optimistic. They believe that once this pandemic problem is solved, the businesses that weather the storm will reap the benefits of outliving the tragic economic effects of this pandemic. Thus, to help you out, our firm compiled questions from various clients concerning the latest government issuance and offers answers to these frequently asked questions. That way, you will know how to use your precious resources as the country reopens the economy. In this webinar, we hope that we can guide you as you emerge from this ECQ slumber and move towards reviving and revitalizing your businesses as you enter the GCQ phase. With that, I shall turn over the floor to our webinar team. Thank you very much.
Thank you, Attorney de Guzman. Of course, this webinar will not be possible without a moderator and speakers who will tackle the implications of the enhanced community quarantine as well as the general community quarantine. The moderator will be Ms. Erica Pua, and the speakers will be Attorney Tanya Andrade, Ms. Bianca Dador, and Ms. Jaline Nostratis. To discuss the House rules, I now give the floor to the moderator, Erica.
Thank you, Mayan. Good afternoon, ladies and gentlemen. I am Erica Pua, your moderator for the day. Before we proceed to the presentation of our panelists, a few house rules must be observed. First, participants other than the panelists are muted. Second, if you wish to ask any question, please type in your questions in the Q&A chat box at the bottom of your screen. Third, questions will be posed at the end of each following topics: the post-ECQ survival and the friendly reminders. Fourth, please click the raise your hand icon if you are experiencing any technical issues. Fifth, we will provide a copy of the materials used in this webinar. And lastly, if your question was not addressed during this webinar, kindly send us email at partners@gsmhlaw.com so we may address it. Back to you, Mayan.
Thank you, Erica. The outline of today's discussion would be: first, the differences between ECQ and GCQ. Second, the guidelines under ECQ. Third, guidelines under GCQ. Fourth, other potential relief. And lastly, our friendly reminders. Without further ado, we will now start the presentation and will first discuss the business preparedness checklist. Attorney Nikki.
Thank you, Mayan. Good afternoon, everyone. So before we started this webinar, we sent an email of containing a checklist. This checklist serves as a general guide to help participants assess the overall performance or preparedness of their companies. So before we get into the general guidelines under ECQ and GCQ, this checklist is a printable format which you may accomplish to assess if your company is ready to restart or resume its operations. So the first task is to confirm, is your workplace under ECQ, GCQ, or barangay lockdown? Please note that there are several issuances for each type of quarantine. And next, is your company allowed to operate under the said quarantine measure? After that, confirm who among your managers, supervisors, or employees are in areas with restricted movements. Check as well if your suppliers and or your customers are in areas with restricted movements. Are there any government issuances or local ordinances that limit or restrict your operations? And if so, what passes or permits does your company or employees require to go in between these checkpoints? The next task would be to view or verify the obligations arising from deferred due dates. First, you have to check what are the taxes and the tax returns due to the Bureau of Internal Revenue. And next, what taxes or fees are due to local governments where your business is operating? Does the company have payments due to SSS, PhilHealth, or its other stakeholders? Or also, does the company have any repertorial requirements due to the BIR, SEC, or DTI for sole props? Does the company have any rental payments due? And lastly, does the company have any debt payments or loans that are due? The third step would be to prepare your employees. Does your company have the required COVID-related company policy to ensure that your workplace is a healthy and safe working environment? Next, is there a need to limit the number of employees you can require to report to work? Are these obligations imposed on your company with regard to are there any obligations imposed on your company with regard to your employees' lodging or transportation? You also have to make sure if your employees are in good health. You can check on them from time to time and whether or not your company can implement additional health and safety measures against COVID-19. And lastly, has the company acquired or installed the necessary protective equipment for its employees and the workplace? Your next task would be to get your office ready. For these, you have to answer the questions of whether your company has inspected the offices for resumption or reopening of operations. Next are the utilities such as water, electricity, and internet fully functioning. Next, has the building administrator for rented offices implemented any health and safety protocols for all building tenants? Aside from those, you also have to check if the company has already implemented safety measures. Is there also a need to limit or customer or client interaction in the workplace? And lastly, does the workplace need to be frequently disinfected? For the last task, it's more of company engagement to send the word out. Has the company announced its resumption of operations? And has it reached out to its clients? These are the majority questions we wish to address and for the participants to take into consideration in assessing the preparedness of their business. Thank you, Mayan.
Thank you, Nikki. And now, to discuss the differences between ECQ and GCQ, I will now give the floor to Bianca. Bianca?
Thank you, Mayan. As what Mayan I will be discussing the concepts ECQ or the Enhanced Community Quarantine and GCQ or the General Community Quarantine. Next slide, please. So in order to understand the concepts enhanced community quarantine and general community quarantine, we at least have to enumerate or know the issuances controlling these concepts. So one issuance is Presidential Proclamation number 929, and then second and third are the memoranda from the Office of the Executive Secretary dated March 16, 2020 and April 7, 2020. Next slide, please. Fourth, the Executive Order number 112, series of 2020. We also have IATF Resolution number 30 and number 31, and memorandum from the Office of the Executive Secretary dated May 2, 2020. So I would like to inform you that the guidelines pertaining to GCQ and ECQ are constantly changing. So we have to be updated of the latest issuances from the government. In fact, just this afternoon, there's a new issuance, the IATF Resolution number 35, which I will be discussing later, which I will discuss later. So in order to understand GCQ and ECQ, we have to at least know the differences between the two. And the differences between the two can actually be gleaned from the definition of each concept. So GCQ refers to the implementation of temporary measures limiting movement and transportation, regulation of operating industries, and presence of uniformed personnel to enforce community quarantine protocols. ECQ, meanwhile, refers to implementation of temporary measures imposing stringent limitations of movement and transportation of people, strict regulation of operations of industry, provision of food and essential services, and heightened presence of uniformed personnel to enforce community quarantine protocols. So, as what I've mentioned earlier, there's a new issue once, which is the IATF Resolution number 35. So, under this resolution, we have another new category. The government has actually added the modified ECQ, which is also considered ECQ, but with several modifications. So under the new guidelines, in ECQ, policies and protocols include no movement regardless of age and health status, minimal economic activity except for utility services such as food, power, and water, and critical economic sector. We also have a policy or a rule which prohibits transportation activity except for utility services. suspension of physical classes is likewise implemented. In the new category or the modified ECQ, the policies and protocols include limited movement within zone for obtaining essential services and work, operation of selected manufacturing and processing plants up to maximum of 50% workforce, limited transporting services for essential goods and services, and suspension of physical classes. In GCQ, moreover, the policies and protocols include limited movement to services and work within the buffer zone and the outside buffer zone, operation of government offices and industries up to maximum of 75% workforce, limited transporting services to support government and private operations, and flexible learning arrangements, which shall operate at limited capacities to cater to students. We also have the fourth category, which is the modified GCQ. It's actually a modified GCQ being implemented outside the buffer zone. So in this category, permissive socio-economic activities with minimum public health standards is being imposed. So we have to note that in ECQ, it is implemented within the critical zones or CRZ. The modified ECQ is being implemented in containment zones or CZ, and GCQ is implemented in buffer zone. We also have modified GCQ outside buffer zones. Next slide, please. So according to IATF resolution number 35, for areas placed under modified ECQ, the new category, the recommendations of the NTF against COVID-19 are adopted in relation to the proposed zoning concept and corresponding qualification and its phased response or intervention. Actually, there's a new order from the President, the Executive Order number 112 series of 2020, which empowers the LGUs to create a regional interagency task force. So the LGUs does not only have the power or the recommendatory power to the IATF regarding their city or municipality, they are also empowered to create a regional interagency task force. Thus, in IATF resolution number 35, they actually included another provision uh, in relation thereto, in which it states that city or municipal LGUs shall be allowed to declare the classification of barangays based on risk thresholds to be confirmed by the RIATF. Next slides, please. So under the new resolution, there are some areas which ECQ has been extended, and there are also some areas which has been changed with respect to their status. So some have become GCQ or General Community Quarantine, and some have become modified ECQ or Modified Enhanced Community Quarantine. So as what I've mentioned earlier, we have these areas which we consider as high-risk areas. So under this IATF resolution, high-risk provinces, HUCs, and ICCs shall be placed under Modified Enhanced Community Quarantine or MCQ until May 31, 2020. So in Luzon, Laguna, and all HUCs of NCR and the municipality of Pateros are put under a modified enhanced community quarantine. Cebu City is also put under MECQ likewise. Next slide, please. So we also have moderate risk areas or moderate risk provinces, HUCs and ICCs, which are placed under GCQ until May 31, 2020. So these areas include Abra, Apayao, Benguet, Ifugao, Kalinga, Mountain Province, Baguio City, Batanes, Cagayan, Isabela, Nueva Vizcaya, Quirino, Santiago City, Aurora, Bataan, Bulacan, Nueva Ecija, Pampanga, Tarlac, Zambales, Angeles City, Olongapo City, Cavite, Quezon, Rizal, Batangas, and Lucena City. Next slide, please. So we also have low-risk areas or low-risk provinces, HUCs and ICCs, which are no longer put under community quarantine. These areas include Ilocos Norte, Ilocos Sur, La Union, Pangasinan, Dagupan City, Marinduque, Occidental Mindoro, Oriental Mindoro, Romblon, Palawan, Puerto Princesa City, Albay, Camarines Norte, Camarines Sur, Catanduanes, Masbate, Sorsogon, Legazpi City, and Naga City. We also have other low-risk areas, and these include Aklan, Antique, Capiz, Guimaras, Iloilo, Negros Occidental, Iloilo City, Bacolod City, Biliran, Eastern Samar, Leyte, Northern Samar, Western Samar, Southern Leyte, Ormoc City, and Tacloban City. Next slide, please. Other low-risk areas also include Bukidnon, Camiguin, Lanao del Norte, Misamis Occidental, Misamis Oriental, Cagayan de Oro City, North Cotabato, South Cotabato, Sarangani, Sultan Kudarat, General Santos City, Basilan, Lanao del Sur, Maguindanao, Sulu, Tawi-Tawi City, and Cotabato City. So, we have a prevailing or current issuance from the DTI Memorandum Circular 20-2022, in which the government through DTI categorized private establishments into 4 categories. So before discussing this, I would like to remind everyone that this is still subject to new issuances by the government, because as what I've mentioned earlier, the new issuance IATF Resolution number 35 may be followed by new guidelines. But for the purpose of this webinar, let us discuss to you what is the prevailing issuance or guidelines for now. So there are 4 categories. Number 1, the first category. Under this category, private establishments are allowed in full operational capacity. Number 2, in category 2, the private establishments are allowed to operate 50% up to full operational capacity and without prejudice to work from home and other alternative work arrangements. Category 2, which allows a maximum of 50% work on-site arrangement and without prejudice to work from home and other alternative work arrangements. And category 4, which are not allowed to operate. So what are the industries falling under category 1? So these industries include agriculture, forestry and fisheries and their workers, including farmers, agrarian reform beneficiaries, fisherfolk, and agri-fishery stores, and its entire value chain. We also have the manufacturing and processing plants and the entire value chain, raw materials, inputs, including packaging, of basic food products, essential products, medicine, and medical supplies. So these include all food and beverages except alcoholic drinks, essential and hygiene products such as soap, detergents, shampoo, and conditioners. Next slide, please. Diapers, feminine hygiene products, toilet papers, wet wipes, and disinfectants. Under this industry, we also include those that are engaged in manufacturing or making medicines and vitamins, medical products such as personal protective equipments, masks, gloves, and pet foods, feeds, and fertilizers. We also have the industries which can be considered as hospital, medical clinics, and health clinics, such as dermatological and other clinics for non-aesthetic, such as dental, optometric, and eye, ear, nose, throat, subject to strict health standards and strict observance of infection prevention and control protocols. So in this industry, the wearing of PPEs by the dentist and attendants shall be mandatory. We also have industries which include retail establishments such as the groceries, supermarkets, hypermarkets, convenience stores, public markets, pharmacies, and drugstores. We also have the laundry shops and the food preparation establishments insofar as takeout and delivery services and water refilling stations are concerned. Under category 1, industries that are also considered under this category are the logistics service providers, such as those engaged in cargo handling, warehousing, trucking, freight forwarding, and shipping lines. Delivery services, whether in-house or outsources, transporting food, medicine, other essential goods such as hygiene products and medical supplies, clothing, accessories, hardware, houseware such as appliances, school and office supplies, including computer accessories, ink, information technology or IT, communications and electronics equipment, pet food, and other veterinary products are also included. The DTI also considered power, energy, water, IT, and telecommunication supplies and facilities, including waste disposal services, as well as property management and building utility services, as falling under Category 1 industries. Next slide, please. So under the same category, we also have electricity, gas, steam, and air conditioning supply services, water collection, treatment and supply, waste collection, treatment and disposal activities and materials recovery, sewerage except emptying of septic tanks, services to buildings and landscape activities except landscape care, but including pest control, garbage collection and disposal, sewer maintenance and treatment. We also consider these industries falling under Category 1 industries. Telecommunication companies, internet service providers, cable, including those who perform indirect services such as the technical, sales, and other support personnel, as well as the employees of their third-party contractors doing sales, installation, maintenance, and repair works. We also considered energy companies, their third-party contractors, and service providers, including employees involved in electric transmission and distribution companies, electric power plant and line maintenance, electric market and retail suppliers, as well as those involved in the exploration operations, trading, and delivery of coal, oil, crude, or petroleum and byproducts, which include gasoline, diesel, liquefied petroleum gas, jet oil, kerosene, lubricants, including refineries and depots or any kind of fuel used to produce electricity. We also have the gasoline stations, construction workers accredited by the DPWH to work on facilities identified for purposes of quarantine and isolation, including such facilities for the health sector, emergency works, flood control, and other disaster risk reduction and rehabilitation works. For the Category 1 industries, manufacturing companies and suppliers of equipment of products necessary to perform construction works and media establishments are also considered. So the next category is Category 2. To recapitulate, under this category, 50% up to full operational capacity is allowed without prejudice to work from home and other alternative work arrangements. So please take note of the second and third column, which will show if the industries that is being discussed is allowed to operate in ECQ or in GCQ. So under the Category 2 industries, other manufacturing activities such as beverages, cement, electrical machinery, wood products or furniture, non-metallic products, textiles, tobacco products, paper and paper products, coke and refined petroleum products, and other non-metallic mineral products, electrical equipment, machinery and equipment, motor vehicles, trailers and semi-trailers, and other transport equipment are considered. So under this category, mining and quarrying, electronic commerce companies, postal and courier and delivery services of all other products not included in Section 2.4F of the Omnibus Guidelines, and the export-oriented companies are also considered to be falling under this category. However, for export-oriented companies, the work from home, on-site or near-site accommodation or point-to-point shuttling arrangements must be provided. Export-oriented businesses shall be allowed to install and transport the necessary work from home equipment to enhance their operations. by providing the services which I've mentioned earlier. So we also consider these industries to be under category 2, the essential public and private construction projects, such as but not limited to sewerage, water services facilities, digital works, health facilities, and priority projects, repair of computers and personal and household goods, housing service activities, and office administrative, office support, and other business activities such as but not limited to photocopying, billing, and record keeping services. So please take note that the last industry is not allowed to operate in ECQ but is allowed to operate in GCQ. So we also considered the following accommodations as category 2. These are the accommodation only for the following: for areas outside Luzon, guests who have existing booking accommodations for foreigners as of May 1, 2020, guests who have existing long-term bookings, distressed OFWs and stranded Filipinos or foreign nationals, repatriated OFWs in compliance with approved quarantine protocols, non-OFWs who may be required to undergo mandatory facility-based quarantine, and healthcare workers and other employees from exempted establishments under the Omnibus Guidelines and applicable memoranda from the Executive Secretary. We also consider the funeral and embalming services, provided that funeral service operators are directed to provide shuttling services and or housing accommodations for their personnel and staff, the veterinary clinics, and security and investigation activities to be falling under this category. So apart from category 1 and category 2, we also have another category, which is category 3 industries, which allows a maximum of 50% work on-site arrangement and without prejudice to work from home and other alternative work arrangements. So these industries include business process outsourcing or BPO companies with work from home, on-site or near-site accommodation, or point-to-point shuttling arrangements. For this purpose, BPOs and their service providers shall be allowed to install and transport the necessary work from home equipment to enhance their operations by deploying their workers under on-site or near-site accommodation arrangements or provide point-to-point shuttle services from their near-site accommodations to their offices. We also consider banks, money transfer services, microfinance institutions, pawn shops, credit cooperatives, including their armored vehicle services, if any, to be falling under this category. So to take note that in ECQ, in this category, may we revert back to the previous slide? In ECQ, pawn shops not performing money transfer is not allowed to operate. So aside from what I've already enumerated, these industries are also considered to be category 3. Capital markets, including but not limited to BSP, SEC, PSE, Philippine Dealing and Exchange Corporation, Philippine Securities Settlement Corporation, and Philippine Depository and Trust Corporation to be included. We also have the industries which can be considered as other financial services, such as money exchange, insurance, reinsurance, and pending funding, except compulsory social security, legal and accounting, and management consultancy activities to be under this category. Other industries also include architecture and engineering activities, technical testing and analysis, scientific and research development, advertising and market research, computer programming such as writing, modifying, testing, and supporting software, planning and designing computer systems, information service activities such as data processing and hosting activities, and other related activities to be falling under this category. So we also have other industries such as employment activities, malls and commercial centers, barber shops, and salons. Next slide, please. Next slide, please. Yes. We also consider the wholesale and retail trade of motor vehicles. And while in category 4, we consider tourist destinations such as but not limited to water parks, beaches and resorts, gambling and betting such as but not limited to cockfighting and casinos, and any other amusement, leisure, gaming, and tourism establishments that promote mass gathering. So in this category, as what I've mentioned earlier, these industries are not allowed to operate both in ECQ and GCQ. Next slide, please. So under this category, we also have the gyms, fitness studios and sports facilities, entertainment industries, amusement industries, libraries, museums, and other cultural centers, art galleries, botanical and zoological gardens. So after enumerating all the establishments or the categories to be considered in ECQ and GCQ, let me discuss to you the guidelines under the ECQ. So in ECQ, minimum public health standards shall be complied throughout the duration of ECQ, and strict home quarantine and movement of all residents shall be limited to accessing essential goods and services and for work in permitted offices or establishments. So we have to know also who are the authorized persons outside of residences or the APOR who can go outside of their homes and go to their workplaces. So under DTI Memorandum Circular number 20-22, the following employees or workers shall be allowed to be outside their residences for purpose of reporting to work in permitted industries under category 1 to 4, business establishments, or to obtain essential goods. So these people can go outside of the residences provided the two purposes are for reporting to work or to obtain essential goods. These people or employees are those with ages below 21 years old, those 60 years old and above, those with immunodeficiency and other health risk, pregnant women, and any person who resides with the aforementioned, who are allowed to go out while in ECQ. So these persons include the pastor, priest, immediate family members of the deceased for other causes other than COVID-19, attending the wake, veterinary clinics personnel, security personnel, repatriated OFWs in compliance with approved quarantine protocols, and non-OFWs who may be required to undergo mandatory facility-based quarantine. There are last two people who can be allowed to go out, and these are the healthcare workers and other employees from exempted establishments and regulatory agencies with jurisdiction over permitted establishments or persons that are tasked to issue official IATF accreditation IDs and bona fide IDs issued by establishments exempted from strict home quarantine requirements shall likewise be honored by law enforcement agencies. So under the ECQ guidelines, in checkpoints, the PNP retains its authority to conduct inspection procedures in checkpoints only for ensuring that protocols on strict home quarantine are observed. So we also have the rapid pass system, which is currently implemented only in NCR. So under the DTI Memorandum Circular number 20-22, the presentment of rapid pass or IATF ID is not already required. They only require the presentment of certificate of employment and ID to be able to gain access to the checkpoints. However, since this is already prevailing and also operating, let us discuss to you the rapid pass system, its natures, and the procedure involved. So in rapid pass bulk application, we can know the details by accessing this link. And this is for individuals, companies, and vehicles needed for essential activities. So in applying for rapid pass, the designated representative from the applying entity should fill out the rapid pass form for persons and execute attestation forms. So there are two forms that must be noted, which are the rapid pass form and the attestation form. Next slide, please. So this is the attestation form that must be uh, supplied or given to the authorities. So here, the procedure, how it works, we have to register at the www.rapidpass.ph and follow the steps to apply for a digital pass. And once approved, the unique QR code will be sent through email and SMS. We can also print the code or save it as a digital photo, as can be seen in the picture in this slide. And for vehicles, the IATF or the government actually recommend printing the QR code and stick it on the windshield for visibility. So the code must be presented to the enforcers who will scan it at designated checkpoints, and the employees who will present these scan or the rapid pass shall also present their valid ID for inspection. So in ECQ and GCQ, we also have to note that the transportation might be affected. So as what I've said earlier, in ECQ, public transportation is actually absolutely prohibited. But in GCQ, public transportation is allowed but subject to social distancing measures. So the pertinent guidelines for this is one that was issued by IATF and DOTR, or Department of Transportation, which is the Omnibus Public Transport Protocols or Guidelines. So in aviation, flights allowed to operate are the following: government and military flights, international flights subject to existing IATF EID or Bureau Quarantine Protocols, air ambulance and medical supplies, flight check and weather mitigation flights, maintenance and utility flights, emergency flights, domestic flights coming to and from provinces and cities under GCQ, subject to required airport clearances and flight plan approvals as may be applicable, and other flights as approved by IATF EID. So in aviation, these are some of the guidelines we must know. The wearing of face mask, face shield, or other PPEs is compulsory for all individuals. So these include the passengers as well. Social distancing measures shall be strictly observed inside ports, ships, and other passenger vessels at all times. Security procedures shall be done through no contact means but not limited to the use of works through X-ray machines, among others. And the regulation of covering the maximum allowable hand-carried bags or items shall be strictly implemented. So in maritime, some of the guidelines include the passenger capacity in ships and other passenger vessels to be reduced to 50%, social distancing measures, which shall be strictly observed inside port ship premises, and the wearing of personal PPEs is also considered mandatory. And upon entry of ports, terminals, and passenger vessels, all individuals shall undergo disinfection procedures such as foot bath, among others. So in roads, I think this is the most important, or which everyone must take note. So some of the guidelines include passenger load for public utility buses or PUBs and public utility jeepneys or PUJs should not exceed 50% or half of the vehicle capacity, excluding driver and conductor. For UV Express and taxis, passenger load should not exceed 2 passengers per row, except for the driver's row where only 1 passenger is allowed. For tricycles, the tricycles must not exceed 1 passenger in the sidecar, while back riding is not be allowed. Is not to be allowed. Yes. The other guidelines also include private cars, which shall only allow 1 passenger to occupy the front passenger seat, while front-facing seats shall not exceed 2 passengers per row, and motorcycles are prohibited from having backride passengers, while the use of bicycles and similar devices are also highly encouraged.
Thank you for that comprehensive discussion, Bianca. And now to discuss the general obligations of employers, I will now hand the mic over to Ja. Ja?
Thank you, Mayan, and hello, everyone. Good afternoon. Welcome to our webinar. I am Jelena Stratis, and I will discuss the general obligations of employers and establishment owners during the ECQ, GCQ, and modified ECQ. Please take note that these guidelines are applicable if you are an establishment allowed to operate during this community quarantine period. So, yes, next slide, please. So the most important obligation of the employer is to develop a company minimum health protocol and standards for COVID-19 prevention and control. These obligations and guidelines are provided for under the interim guidelines on workplace prevention and control of COVID-19, a joint issuance of the Department of Trade and Industry and the Department of Labor and Employment. So these are the specific protocols that must be included in the company policy. Number one, provide resources and materials to keep workers healthy and safe. For example, the employers shall provide the masks, soap, sanitizers, and disinfectants. Also, the PPEs and the COVID-19 testing kits if necessary. Also, the employer shall designate a safety officer to monitor COVID-19 prevention and control measures. The employer shall also enhance health insurance provisions for its workers. And if feasible, the employer shall provide shuttle services and or decent accommodation on near site locations to lessen the travel and people movement of their employees. But please take note that for some industries, like for BPOs and export establishments and for healthcare workplaces, they are obliged to provide transportation and accommodation for their employees. Next, the employer should also put up a COVID-19 hotline and call center for its employees to report if symptomatic and to provide a daily monitoring scheme of suspect employee condition. These pertain to employees who are suspected of having the COVID-19 disease. And also, the employers shall provide DOLE Regional Office and DOH a monthly report of illnesses, diseases, and injuries of their employees by using the DOLE Work Accident/Illness Report form. This form is provided for at the DOLE and the DOH website. So under the DTI Memorandum Circular number 2022, and as stated earlier by Bianca, it is the employer's obligation to secure the IATF IDs and the rapid passes for the movement of their employees during this community quarantine period. Also, please remember that we should follow the DOH Admin Order number 2020-0015 for public health standards prescribed in offices and workplaces. So the four objectives of these standards is number one, increase physical and mental resilience of our employees. Number two, reduce transmission of COVID-19. Number three, reduce contact. And number four, reduce duration of infection. So also among the guidelines that were not enumerated in this presentation but provided for in the interim guidelines of DTI and DOLE are the employers are enjoined to provide free medicines and vitamins for their employees, and also to provide referral for workers needing counseling or presenting with mental health concerns. Also, the employers shall put up an isolation area in their premises, which shall be well ventilated and which must be disinfected frequently. So going back to our slides, for the workplace safety and health prior to entrance in buildings or workplaces, yes, all employers and workers, please take note that this applies to visitors and guests as well, must wear masks at all times. For employees and workers, they may only remove their masks if they are eating or if they are drinking. So visitors and employees must have their temperature checked and recorded, and they must also accomplish the daily health symptoms questionnaire. It is also important that the employees spray alcohol to both hands prior to entrance to the office, and to provide and for the employers to provide food bags at the entrance if practicable. Next slide, please. So please remember that the employer should also disinfect equipment or vehicle entering the operational hub. So the disinfection is not only limited to persons, but also to equipment, to vehicles, to everything that enters your premises. And also, please keep in mind to instill physical distancing of 1 meter. So whether it is outside or inside your premises, still observe physical distancing. Next slide, please. So this is the sample protocol for screening employees and visitors. This pertains to the temperature of the individual entering your premises. So the most important part here is, if your temperature is 37.5 degrees Celsius, you will be led to an isolated holding area and you will rest for 5 minutes. And if after 5 minutes, your temperature is still 37.5 degrees Celsius, you would be observed and attended to by a doctor or a nurse. If after 5 minutes, your temperature is higher than 37.5 degrees Celsius, you will be denied entry to the premises. If lower than 37.5 degrees Celsius, you may enter the premises, but you will have to accomplish the visitor's checklist first. Next slide, please. Yeah, so this is the DOLE provided visitors checklist. This is available on their website, and we can also provide this for you. This is the sample template. Please read. So the name, the residence. So just template questions to determine if you may be suffering some symptoms that is related to the COVID-19 disease. Next, please. So what are the workplace safety and health protocols inside the workplace? So I'm sure that most of you are already observing these protocols, but just to reiterate, because it is important that these protocols form part of your company policy, because the DTI and the DOLE actually requires the workplaces to really come up with a company policy. So first, you should clean and disinfect at least once every 2 hours all areas and frequently handled objects. So at least once every 2 hours. So you should also provide sufficient clean water and soap in all washrooms and toilets. Please provide disinfecting soap and not just scented soap. So you should also encourage workers to wash hands frequently and avoid touching face. And you should provide sanitizers in corridors, conference areas, elevators, stairways, and areas where workers pass. Next slide, please. So this is also one important provision provided for under the interim guidelines. According to the DOLE, the employers may test their workers for COVID-19. However, the testing of workers and interpretation of results shall be in accordance with the memorandum and the issuances of the DOH. So, according to the interim guidelines, testing kits used and procured shall be for the responsibility of the employer. So it is the responsibility of the employer to procure testing kits if they decide to do so. And under the DOH guidelines, the companies may formulate their own policies, provided that this policy is agreed upon by the employers and the workers. So also please be reminded that the priorities for testing are workers with symptoms or those who have been exposed to probable or confirmed cases of COVID-19. This is considering the scarcity of our COVID-19 testing kits. Next slide, please. So what are the obligations of employers if an employee is suspected of having or being infected of COVID-19? So please take note of these 4 major protocols that you should observe if one of your employees is suffering from COVID-19. First, the suspected employee should immediately proceed to the isolation area, that one which I mentioned earlier. Number 2, The employer shall transport the employee to the nearest hospital for testing. Please also be mindful of the specific hospitals that are designated to specially cater to COVID-19 patients or cases. Number 3, you should decontaminate the entire workplace. And number 4, ask employees who were in the workplace or who had interaction or contact with that COVID-19 patient or positive employee to undergo a 14-day home quarantine. Next slide, please. So this is the explanation of the decontamination of workplace. So workplace shall be, if a worker is a COVID-19 suspect, the workplace shall be decontaminated with appropriate disinfectants. Actually, the DOH issued several memorandum and guidelines as to what substances are proper to disinfect your premises. So if you wish to know about that, you can message us so we can provide you with that copy of the circular. Also, after decontamination of the work area, work can resume only after 24 hours. And as mentioned earlier, workers present in the work area with the suspect COVID-19 worker shall go on 14 days home quarantine. Next slide, please. So what if your worker is sick or he does not show any other symptoms of COVID-19, but he is sick, he has fever, but he is not a COVID-19 suspect? So you must advise your employee, stay at home, keep away from work or crowds, take adequate rest, and drink plenty of fluids, and practice personal hygiene. So in this case, it is important that you advise your employee to not report to work because we are not 100% sure if he is really not COVID positive. Next slide, please. So next slide, please. So let's proceed to the repertorial requirements. So even though some of us are not fully operational during this community quarantine period, these are the repertorial requirements that we are still obliged to fulfill. And actually, this is only a mere reiteration of our previous webinars, which was an in-depth discussion on the BIR issuances and the SEC issuances. Next slide, please. So for SEC, for example, for your annual report, audited financial statements, general information sheets, please be reminded again that the general extension is moved to June 30, the deadline is moved to June 30, 2020. And please take note of the relaxation on documents requiring notarization. So according to the issuances of SEC, electronic signatures may be used, and reports may be submitted unnotarized, and every submission must be accompanied by a certification of the person who prepared it that the information therein is true and correct. So there are no issuances yet for operations under GCQ and for MECQ, but we can still assume that these existing issuances under the ECQ shall still apply. Next slide, please. So for BIR, so the general deadline, the general extension of deadline for filing and payment of taxes is 30 days from May 15, 2020. So just to remind you, so for the filing of tax returns and payment of taxes for value-added tax and percentage tax or excise tax, which the original date of which fell due on March 16 to April 15. The extended due date is 60 days from the original due date. So for income taxes and withholding taxes, the original due date of which fell on April 16 to 30, the extended due date is 45 days from the original due date. So for documentary stamp tax and other reports, which fell due on May 1 to May 25, the extended due date is 30 days from the original due date. So for other documents like position papers and other reportorial requirements, the extended due date is 30 days from lifting of the quarantine. So here in our presentation, it was indicated May 15, 2020 because it was prior to the earlier declarations at the MECQ is imposed here over the NCR. So please also remember that there is a documentary stamp tax exemption for restructured or extended loan agreements when the original due date fell during the ECQ period. And also, please remember the donor's tax exemption for donations in support of COVID-19 response. Next. So for DOLE, what are the reportorial requirements that are related to the COVID-19 or to the ECQ? Number one, the establishment report on COVID-19. This is a report that you will submit if you will file a notice of flexible work arrangement or a notice of temporary closure. So you will file an establishment report and a notice of flexible work arrangement at least 1 week prior to the implementation of the flexible work arrangement. And you will file this report and notice of temporary closure at least 30 days prior to the effectivity of your temporary closure. So the next document is the DOLE monthly work accident or illness report form. This is a form that shall be submitted by the employer for every accident or illness on or before the 20th day of the month following the illness of their employees. So next slide, please. Next slide, please. So this is the employer's work accident illness report form, which is a template provided for by the Department of Labor and Employment. It is also available at their website, but we can also provide this form for you if you just message us after this presentation. That's it for my part, and you can ask questions and we can entertain them after some post-ECQ release. Thank you, Mayan.
Thank you for that extensive discussion, Ja. May I remind everyone that we will be running a live question and answer at the end of the presentation of our next speaker. So if you have any questions, please type them in the Q&A chat box at the bottom of your screen. And now to discuss the post-ECQ survival, I will now give the floor to Nikki. Nikki?
Hi, everyone. So just to add to what Attorney Jerome de Guzman mentioned, companies right now are aiming to survive and thrive through this COVID-19 pandemic. So we have provided some post-ECQ survival relief measures provided by the government. So under the Bayanihan to Heal as One Act, the following reliefs have been provided by the government. They have provided grace periods for payments and mandatory employee benefits, moratoriums on loans, deferment on the remittance of premium remittances, extension of submission of documents, deadlines, and renewal of permits, as well as waiver of certain transaction fees. I'll go into detail to each of these reliefs provided. So for the grace periods, I'll first tackle rents. This covers residential and commercial rents of SMEs, MSMEs that ceased operations. Please take note that the rents covered here are those falling due within the duration of the ECQ or GCQ. Also, there is no interest, penalties, and charges that will be incurred for the late payment. So the grace period for rental payments is 30 days from the last due date or until such time that the community quarantine is lifted, whichever is longer or later. Aside from the 30-day grace period, if there are cumulative amounts of rent, the said cumulative amounts shall be equally amortized in the 6 months following the end of the community quarantine and shall be added to those succeeding months. Aside from rents, there is also a grace period for electricity bills. As such, distribution utilities and retail electricity suppliers such as Meralco shall provide a minimum 30-day grace period based on the last due date of the bills, which fall due within the ECQ period of March 16 to May 15, 2020. they also provided a cumulative amount of utilities payable that may be amortized in 4 equal monthly installments in the 4 succeeding billing months. Aside from grace periods, the government has also provided loan moratoriums for those that fall due within the duration of the ECQ. Also, no interest penalties, fees, and surcharges shall be incurred. For loans, the covered establishments includes banks, financing companies, lending companies, as well as government lending institutions. The grace period provided is also 30 days, while lending institutions may also provide a qualified 30-day grace period. For Pag-ibig Fund, aside from the mandatory 30-day grace period, they have also provided an optional 3-month moratorium. I will discuss this more in detail later. First, the BSP implemented Memorandum Number 2020-17 to reinforce and implement the Bayanihan to Heal as One Act. Based on this imposition of the mandatory 30-day grace period for payment of credit card bills, we have compiled several frequently asked questions. So the first one is, for credit card transactions, will interest accrue on the outstanding balance during the 30-day grace period? So no interest will accrue on the outstanding balance during the said 30-day grace period. For credit card revolvers or those borrowers that do not pay in full every payment period, interest will continue to accrue until the next due date after the application of the 30-day grace period. The next frequently asked question is, do borrowers need to apply or request for approval from the lending financial institutions for the application of the 30-day grace period? The answer is no. The grace period here is mandatory and will automatically apply. We advise that should the 30-day grace period not be automatically applied, to request with the financing institution or the bank for the application of the 30-day grace period. Next, are covered institutions allowed to require their clients to waive the application of the mandatory grace period? Again, no, covered institutions are prohibited from requiring their banking clients to waive the application, as this is mandatory. So what are the consequences of non-compliance with the provisions of the implementing rules and regulations under the Bayanihan to Heal as One Act? So failure of financing institutions or covered institutions to implement the said 30-day grace period will result in the imposition of a fine from 10,000 to 1 million and or 2-month imprisonment of the responsible individuals. Now, to discuss further in detail the Pag-ibig Fund I mentioned earlier, so aside from the 30-day grace period, Pag-ibig has provided a 3-month optional moratorium wherein the member himself or herself must apply online via the Pag-ibig online portal. Please take note that the applications will be accepted until June 15, 2020. The loans covered under this moratorium, as well as the mandatory grace period, include housing loans, multi-purpose loan, and calamity loan payments. For premium remittances, the government has allowed insurance premiums or contributions on installment payment to remain unpaid during the period from March 15 to April 20 to provide an extension of at least 31 days. For SSS and PhilHealth, employee contributions for the months of February, March, and April have been extended. For SSS, the deadline payment is June 1, 2020, while for PhilHealth, the premium payments shall be until May 31, 2020. Please also take note that employers required to submit the SSS sickness form sickness notification were given an extension from an original 5 days to now 60 days. These are the materials provided by SSS in their website. As you can see in the rightmost poster, the employer to SSS notification has been extended to 60 calendar days after receipt from employee. For PhilHealth, these are the materials they have released to ensure that PhilHealth will reimburse in full all COVID-19 patients. The next relief provided is the extension of reports, deadlines, and renewal of permits. The Land Transportation Office has extended the validity of registration of motor vehicles and driver's licenses for 60 calendar days from work resumption, while there will be no penalties for the late registration of vehicles purchased since March 5 up to resumption of work. For temporary operators permits, which expired during the ECQ, these permits shall no longer authorize the driver to use TOP as a temporary license. For the Department of Trade and Industry, PS licenses for those issued to manufacturers that have expired by May 31, 2020 shall be provided a period of extension of until July 31, 2020 to submit their documents for recertification and renewal of license. For business name registration, the DTI has provided their online registration portal, which is provided in this PowerPoint presentation. Aside from the business registration, the holders of sea freight forwarding accreditation, merchandise and shipbroker certificate, as well as the submission of the quarterly cargo statistics report, have been given an extension as well of 30 days from the lifting of the extended enhanced community quarantine. And that covers the reliefs provided by the government under the Bayanihan to Hilas 1 Act.
Thank you for that in-depth discussion, Nikki. And now for our question and answer portion, I now hand it over to Erica. Erica?
Thank you, Mayan. We will now conduct the question and answer portion of the first part of today's webinar. We have listed your questions and will ask our panelists for their answers and clarifications. We also acknowledge the presence of our law firm's partners who will from time to time also provide their insights. Please be noted that our panelists' answers are only for purposes of discussion and will not constitute as professional legal advice. If you have more specific questions in relation to your particular circumstances, please send us an email at partners@gsmhlaw.com and we are happy to assist you. Without further ado, we will now start our Q&A. We have several questions here from Mr. Jerome Pampolina. The first one is, what is the procedure if a company wants to implement a forced leave program of a portion of its workforce?
Hi, Erica. I will answer that question. Hello? Yes. So the following procedures must be taken before a forced leave can be implemented during the ECQ. Number one, there must be a consultation with the affected employees, taking into account the adverse consequences of the situation. Number two, employers must post a copy of the Labor Advisory number 9-2020 in a conspicuous location in the workplace. And number three, the employer must file a notice to DOLE through the regional office, which has jurisdiction over the workplace, of its adoption of such forced leave and attach an establishment report on COVID-19. Also, please be reminded that the employee must first maximize and utilize his or her leaves before before he can resort to forced leave.
Thank you, Jalin. The second question is, are employees on forced leave entitled to camp benefits?
Yes, employees under forced leave are entitled to camp benefits because the camp benefits may be availed of by employees who suffer from the no work, no pay policy. However, please be reminded that the application for camp is now closed. Thank you.
Thank you. The third question is, does the company need to pay these employees SSS or pag-ibig contributions?
Yes, during this forced leave setting, they are still considered employees. So the employer must still pay the contribution for the SSS, pag-ibig, and everything. Thank you.
Is there a period that these employees are allowed to be on forced leave, or is it left to your discretion of the company? And can such program last for about a year?
So the employer can still resort to the forced leave setting after the ECQ and GCQ. However, it should be done with consultation with the affected employees, and the notices should also be complied with. But take note that the forced leave setting cannot last for more than 6 months, because after 6 months, such setting will be deemed as constructive dismissal on the part of the employer. Thank you.
Thank you. And last question from Mr. Jerome Pampolina. Can an employee on forced leave obtain other temporary employment or income while on forced leave and then return to the company without loss of tenure?
So if, for example, an employee is placed on a forced leave or a floating status, for example, for 6 months, if such employee have found gainful employment elsewhere, he or she has considered to have severed their employment with his previous employer. Thank you.
Thank you. And we have 2 questions from Mr. Noel Sikat. The first question is Rapid Pass required under the modified ECQ?
All right, so considering that the modified ECQ only provides for additional manufacturing industries that are allowed to operate during this community quarantine period, the Rapid Pass should also be presented and availed of by the employers and should be presented by the employees when crossing checkpoints. And also, please remember that you can also present your company IDs or your IATF IDs if you still do not have your Rapid Passes. Thank you.
All right, thank you. And the second question is mass testing required for companies?
According to the DTI and DOLE guidelines, the mass testing for the workplace or for companies are not required. If I may refer you to the DTI and DOLE interim guidelines, this is what actually is stated. So I will just read it. Under section 6 or section 7 of the Omnibus Guidelines or DTI and DOLE interim guidelines on workplace prevention and control of COVID-19, employers may test workers for COVID-19. So it's only permissive. And in which case, if the employer shall decide to test workers for COVID-19, they shall be the one to procure the testing kits that will be used. And this will be subject to the prevailing DOH memorandum, orders, or circulars and guidelines.
Thank you, Bianca. We have a question here from Mr. Ronnie Pulga. Are we allowed to submit illness report if we are temporarily closed?
Hi, Mr. Rodney. So this illness report, this monthly illness report, should only be submitted if the establishment is operational during the community quarantine period. So if you are not operational during this period, you are not mandated to submit this illness report. Thank you.
Thank you, Ms. Jalin. We have a question here from Ms. Patricia Reyes. Since ECQ is extended to modified ECQ for NCR until May 31, does this mean that the electric bills that have become due within this period can be deferred 30 days after May 31? And how about for SSS and PhilHealth contributions?
All right, so let me answer with regards to the electric bills. So for the electric bills, under the ERC issuances on last May 5, so electric bills that have accumulated shall be amortized into 4 months and shall be payable in 4 equal monthly installments for the succeeding billing months. However, the ERC provided that the payment shall only commence on May 30. This was considering that the ECQ was then announced to take effect only until May 15. So considering that the ECQ is extended, we would most likely be expecting a new issuances extending this period for payment. Thank you.
Thank you. We have a question here from an anonymous attendee. Can we use vehicles with expired registrations?
Based on the LTO issuance, you can still use vehicles with expired registrations. LTO has allowed the use of vehicles with expired registration and has actually extended the application for renewal of registration upon resumption of work.
Thank you, Nikki. We have a question here from Ms. Marisol Ramirez. How can we continue all pending court cases?
For court cases, the Supreme Court has not yet issued any guidelines with regard to the continuation of court cases or hearings on court cases, but has already started pilot testing online court hearings starting with criminal cases.
Thank you. And we have another question from Ms. Marisol Ramirez. What if I have paid advance rental for residential property during ECQ?
For advanced rental, under the existing DTI guidelines, the grace period is for payments due where the person renting cannot pay it during the ECQ, but it does not affect those persons who have already paid rent in advance.
Thank you. We have last question here from Mr. Ronnie Pulga. For temporarily closed companies, are the employers allowed to pay the employees' contributions of SSS or PhilHealth and Pag-ibig while the employee has no earnings?
Yes, per the latest issuances from the SSS and PhilHealth, the employers are still required to pay the contributions for the employees.
Okay. We have another question from Mr. Noel Sikat. Does PhilHealth covers 100% of hospitalization?
Yes, based on the current issuances of PhilHealth, the benefits have already included all hospitalization and medical expenses for patients who have acquired COVID-19.
Thank you, Nikki. At this point, we will address your other questions at the end of the friendly reminders. Back to you, Mayan.
Thank you, Erica. We loved hearing from you during today's presentation. So if you still have any questions for our speakers, please feel free to type them in the Q&A chat box at the bottom of your screen. And now to discuss loans and other financial assistance, other potential relief, and our friendly reminders, I now hand the mic over to Nikki. Nikki?
So just to continue my earlier discussion, I will be focusing now on the financial relief packages provided by the government. These include mostly loans from DTI, SSS, Pag-ibig, Land Bank, and Development Bank. So I'll go into each of these loans available or programs available. For DTI, it has for existing loans with Small Business Corporation, which is the financing arm of DTI, they have provided a 1-month moratorium for loan payments. Aside from that, DTI has also launched the Pondo para sa Pagbabago at Pag-asenso, or the P3 program, which will be implemented by Small Business Corporation. Now, the aim of this P3 program is to provide enterprise rehabilitation financing to cater to micro and small businesses. Now, please take note that micro businesses are those with assets that do not exceed 3 million, while small enterprises are those with businesses whose assets do not exceed 15 million. The total fund allocated for this program is 1 billion pesos. Now, how much can a business loan from Small Business Corporation? For micro enterprises, they can borrow from a minimum of 10,000 pesos to 200,000 pesos, while small enterprises can borrow up to 500,000 pesos. Their interest rate is at a 0.5% per month. So this is the P3 program provided under the Enterprise Rehabilitation Financing. For qualifications of borrowers, it must be 100% Filipino-owned micro or small enterprises operating for at least 1 year prior to March 16, 2020. And of course, as the limitation imposed by DTI, the business must not have an asset size of more than 15 million pesos. The loan payment terms are from 12 months to a maximum of 24 months with a grace period, exclusive of grace period, which will be dependent upon the assessment of Small Business Corporation. I'm flashing now the documentary requirements for small enterprises as well as micro enterprises for them to avail of the P3 program. We can provide this, we will be providing this PowerPoint for your reference. Aside from the P3 program of DTI, we also have the SSS Calamity Loan Assistance Program. While this loan is targeted mostly to targeted for SSS members, it's also important to know since a loan obtained by an employee through SSS will be coursed through the employer who will be making the deductions. So please take note that the members must have at least 36 months of contributions and posted within the past 12 months on or before the application. The member must not also be a delinquent borrower and must not have availed of any of the SSS benefits such as permanent disability, death, and retirement program. The maximum loan amount is equal to a 1-month salary or 20,000 pesos with an interest rate of 10% per annum. The repayment period here is 27 months, inclusive of the 3-month moratorium period provided by SSS. The service fee here is likewise waived. So these are the informational posters provided by Pag-ibig or HDMF in their website and their Facebook social media account. The forms for the Pag-ibig Fund Calamity Loan are available in the displayed websites. Next, another program is the Phil Guarantee Credit Guarantee Facility. Now, this program um, aims to assist MSMEs who wish to obtain a loan of not more than 50 million pesos. Now, what does Phil Guarantee do here? They will guarantee up to the 50% of the loan principal amount as long as the loan is for working capital and the term of the loan must not exceed 5 years. So borrowers must be able to show that they are MSMEs affected by the COVID-19 pandemic. As earlier mentioned, there are the companies, the government institutions have waived certain transaction fees. Under Phil Guarantee, they have all the origination fee, but retain the 1% per annum guarantee fee. Now, the repayment or collateral required for this facility will depend on the banking institution which will facilitate the loan. Another notable financial assistance program is Land Bank's iRescue program. So this is a fund which consists of 10 billion initial internal funding, where Land Bank aims to assist MSMEs, cooperatives, and microfinance institutions in the rehabilitation of their credit programs as well as loan restructuring. For rehabilitation credit programs for SMEs, if they allow credit programs provided that these are emergency funds for working capital, and the interest rate is 5% per annum with a penalty of 24% per annum. Please take note that this program is dependent upon Land Bank's internal credit scoring system. The documentary requirements include the application form, proof of business, such as the SEC Articles of Incorporation and Bylaws, or DTI Certificate of Registration. As the company must also provide the appropriate resolutions or corporate secretary certificate confirming that the company or borrower wishes to avail of the said loans. Aside from that, a notable requirement as well is the audited financial statements of the company for the last 3 years, plus the current year's financial statements. For cooperatives, they have likewise provided for a credit program to enable small farmer and fishers, as well as micro, small, and medium enterprises to avail of a loan that with a loan period of not more than 5 years. The same interest is applied over 3 years with a penalty for co-ops at 3% per annum and 24% for microfinancing institutions. For this credit program, the principal payment is payable upon maturity of promissory notes as well as interest, and the payment shall be made through the deposit accounts with Land Bank. Please note that there is also a risk acceptance criteria here that shall be computed by Land Bank's internal credit evaluation. The third program is rehabilitation through loan restructuring. So if a borrower already has an existing loan with Land Bank, they may avail of this program, which allows the loan to be extended over a period of not more than 10 years with a 3-year grace period. And lastly, we have the response program of Development Bank of the Philippines. Here, borrowers covered are public and or private institutions operating in areas declared in a state of calamity. Now, what are the eligible projects under this program? Those are projects located in areas affected by calamities or force majeure events as determined by the appropriate authorities. Please take note that you must be able to provide the said declaration of the existence of a calamity and a certification from the project head that the calamity has occurred in your area. The loan amount here is based on the project requirement, which the DBP will assess. The interest rates will depend on the institution applying for the response program. Please also take note that you are required to open a bank account with DBP where the loan proceeds will be credited. And this program is also payable on monthly or quarterly basis, depending on the projected cash flows or the agreement with DBP. That concludes all the financial relief measures provided by the government. Now, my next topic includes other potential reliefs that we identified as an option for companies. Now this relief package contemplates two scenarios. So, for example, a company has sufficient assets but cannot meet its obligations when they fall due. Or a scenario where a company incurs substantial loss of income, yet despite the resumption of operations, can no longer sustain its expenses and pay its obligations when they fall due. So based on these two scenarios, the law provides for a financial device or a remedy for these distressed companies. These are remedies provided under the Financial Rehabilitation and Insolvency Act of 2010. So what are the potential reliefs a company may avail of under the Financial Rehabilitation and Insolvency Act? We have suspension of payments, financial rehabilitation, and liquidation. So what is suspension of payments? It's a summary proceeding that enables an insolvent debtor to be restored to a condition of successful operation and solvency. It also helps an insolvent debtor defer payment of debts as they fall due. So who is considered as an insolvent debtor here? It's a person, a resident and citizen of the Philippines who is unable to pay his liabilities as they fall due in the ordinary course of business, or his liabilities have become greater than his assets. So it is a remedy available to an individual debtor who, possessing sufficient properties to cover all his debts, foresees the impossibility of meeting his obligations when they fall due. So how can an individual avail of this remedy? We recommend that you consult first your legal counsel, as this involves the filing of a petition with the court where your business or you may be residing to provide support that you have incurred such amount of debt, and to be able to show that you have certain assets available that may cover the debt. However, the obligations cannot be met when they fall due, along with a proposed agreement with your creditors. So what happens when a court deems a petition for suspension of payments properly filed? The effects are that no creditor will be able to sue or institute um, proceedings against you to collect his claim. However, the claims, not all claims, as a, not all claims shall be forestalled because the law provides for certain exceptions. Those that have claims for labor, maintenance, expense for last illness and funeral of wife or children, as well as secured debtors, are not covered by this petition. Here is a brief overview of the procedure of suspension of payment when you file a petition for suspension of payment. After filing, if the court deems it sufficient, the court will order the holding of a creditors meeting to verify all the claims listed by the insolvent debtor. And after that, the creditors must likewise agree uh, and make it in writing as to the schedule of payments. Once this agreement is signed by the creditors as well as the insolvent debtor, the proposed agreement will be submitted to the court for approval. And once the court approves the proposed agreement, it shall be enforced. So what will happen during the pendency of the petition? As I earlier mentioned, a creditor's meeting will be called by the court, and the court will appoint a commissioner who will preside over the meeting with the creditors. Each of the creditors must present their evidence of claim against the insolvent debtor, and the creditors and debtors shall discuss the possible terms for the repayment of their claims. So what is the effect of the approval of the agreement? The approval of the agreement shall hold in abeyance any claims against the debtor pursuant to the agreement approved by the court, except for, as earlier mentioned, those claims involving personal labor, maintenance, expense for last illness, and funeral expenses for wife and children, as well as secured debtors. Now, what is the effect if the insolvent debtor fails to perform his obligations under the approved agreement? Now, all the rights of the creditors prior to the filing of this petition shall revest in them, where they may be able to institute their own proceedings. So, is an insolvent debtor allowed to operate during the pendency of the petition? Yes. The insolvent debtor may operate his business and pay the legitimate expenses. What is merely prohibited uh, during the pendency of the petition is the disposal or selling of his assets. The next remedy available to a distressed company is financial rehabilitation. So what is rehabilitation? It is the process of restoring the debtor to a condition of successful operation and solvency. Now, if you filing a petition for financial rehabilitation may be voluntary, involuntary, which in both cases are court supervised. There may also be a pre-negotiated rehabilitation and an out-of-court or informal restructuring or rehabilitation plan. I'll be discussing each one to provide a snippet of information for a company's consideration. So the voluntary rehabilitation is filed by the insolvent debtor himself. The insolvent debtor may be the owner of a sole proprietorship, majority of partners in case of a partnership, and for corporations through a majority vote of the board of directors as authorized by the stockholders, representing at least 2/3 of the outstanding capital stock. What are the grounds when filing for a petition for voluntary rehabilitation? So A company may file for financial rehabilitation if one or more of its members foresee the impossibility of meeting debts when they respectively fall due, or that financial distress would likely affect the financial condition and or operations of the company. Please note that the company must also submit a rehabilitation plan to outline its financial viability and ability to pay its creditors. What are the effects if the court um, acts favorably on the petition for voluntary rehabilitation? So, when the court deems the petition sufficient in form and substance, the debtor is declared under rehabilitation. This is done by the court issuing a commencement order and may also issue a stay order prohibiting the sale or disposition of assets of the debtor and ordering the suspension of all actions against the debtor. The court will also direct creditors to file their notice of claim and allow the debtor to continue operating its business while undergoing rehabilitation. Okay, so how about involuntary rehabilitation? Involuntary rehabilitation is a scenario where the creditors representing at least 1 million or 25%, 1 million pesos claim or 25% of the subscribed capital stock of a distressed company may file for involuntary rehabilitation to ensure that their claims may be paid. So what are the grounds for involuntary rehabilitation? First, there must be no genuine issue on the claims and that the due and demandable payments have not been made for at least 60 days. Also, the debtor has failed to generally meet its liabilities as they fall due, or at least one creditor other than the creditor initiating the petition for involuntary rehabilitation has initiated foreclosure proceedings against the debtor that may prevent him from paying his debts as they fall due or render him insolvent. This is also a brief overview of the procedure for financial rehabilitation. Now, after filing of the petition, the court will issue the commencement order, which may also include a stay order, and after such, will appoint a rehabilitation receiver. The rehabilitation receiver serves as the sort of guardian of the company to ensure that it can be restored to a condition of solvency. The rehabilitation receiver will also oversee the implementation of the the rehabilitation plan once it is approved by the court. Now, the next type of rehabilitation is a pre-negotiated rehabilitation. Under pre-negotiated rehabilitation, the debtor or jointly with any of its creditors may file for petition for pre-negotiated rehabilitation, provided that at least 2/3 of the liabilities of the debtors are being claimed by its creditors, or that such creditors hold secured claims that are 50% of the total secured claims, and unsecured creditors holding more than 50% of the total unsecured claims. So what is the effect of a court-approved pre-negotiated rehabilitation? It is equivalent to a court-approved rehabilitation plan. So under pre-negotiated rehabilitation, what is different here is after the court finds the petition to be sufficient, there is a period for filing of objections in case any of the creditors disagree with the rehabilitation plan. But upon approval of the rehabilitation plan by the court, it shall be strictly enforced by those creditors who are part of the list of creditors under the rehabilitation plan. Lastly, we have out-of-court rehabilitation proceedings. So here, How is out-of-court rehabilitation initiated? It is initiated by the insolvent debtor and creditors who wish to seek court assistance for the execution of a rehabilitation plan or agreement that they have agreed upon um, on their own. So what are the minimum requirements for an out-of-court rehabilitation? First, you need the consent of the debtor. Next, the approval of creditors representing at least 67% of the secured claims, as well as approval of the unsecured creditors with at least 67% of the unsecured claims, or the approval of the creditors holding at least 85% of the total liabilities. What is unique about out-of-court rehabilitation is that the agreement may provide for a standstill period. Now, what is this standstill period? It is the period agreed upon by the debtor and his creditors to enable them to negotiate and enter into an agreement or formulate the rehabilitation plan itself. Once the court approves this agreement, it has the same legal effect as that of a court-approved rehabilitation plan. Lastly, we have liquidation. Now, liquidation is a remedy afforded to an insolvent debtor whose properties are not enough to cover his liabilities and owes at least debts exceeding 500,000 pesos. So what are the modes of liquidating an insolvent debtor? We also have voluntary and involuntary liquidation. So by applying for court assistance, the court will assess whether or not the best option for the company would be indeed to undergo liquidation. So once assessed by the court that liquidation is the proper remedy, the court shall issue a liquidation order which has the following effects. The debtor is deemed dissolved. Legal title and control of all its assets will be vested in the liquidator. All contracts of the debtor shall be deemed terminated and or breached unless the liquidator declares otherwise. No separate action for collection of an unsecured claim shall be allowed, and no foreclosure proceedings shall be allowed for a period of 180 days. And that concludes all the potential reliefs that a distressed company may look into. And lastly, before we end our webinar, I'd like to provide some friendly reminders. So while businesses adapt to the new normal, please keep in mind the following tasks we can do to help fight the pandemic. Now, we'd like to remind businesses to pay their taxes, as the government as well needs this funding in order to combat the COVID-19 pandemic. Please also keep in mind to update your employer information with SSS, Pag-ibig, and PhilHealth if you should so choose to temporarily suspend or close or resume business operations. Please also do not forget to file your annual reports such as General Information Sheet, annual financial statements, and tax returns. If you have any intellectual properties, please make sure to update your registrations with the Intellectual Property Office. And lastly, please take note of the adjusted reportorial requirements based on the extended deadlines provided by the respective agencies. Here are some slides with regard to the extended deadlines, and this was discussed earlier by Jack. So BIR has provided quite an exhausting list of all the taxes due from their original deadline to the new deadline provided under Revenue Regulation number 11-2020. Another notable publication as well is from the Securities and Exchange Commission, who has provided a concise table for each type of corporation, whether it's non-stock or stock corporation. And that concludes my friendly reminders.
Thank you for that thorough discussion, Nikki. And now for our question and answer portion, I now hand it over to Erica. Erica?
Thank you, Mayan. We have questions here from our participants. The first question is from Miss Patricia Reyes. Are rent collections deferred after May 31 within the NCR? I think we're having some technical difficulties. I'd like to repeat my question. Are rent collections deferred after May 31 within the NCR?
Yes. So as of now, there is no updated issuance as to the extension until May 31. According to the latest issuance of DTI, the grace period is a minimum of 30-day grace period from the last due date or until such time that the community quarantine is lifted. So in our case, the grace period shall be extended until May 31. But please also take note of the accumulation of the amortization of rents in case they are accumulated. The rent shall be equally amortized in the 6 months following the end of the ECQ. And the amortized rent shall be added to the rent due on the succeeding month. Thank you.
Thank you, Jalin. Our second question is from an anonymous attendee regarding PhilHealth coverage on COVID-19. Can our OFW or seamen avail the benefit or reimburse the cost of COVID testing? Please take note that our OFWs were advised to pay for the cost upon testing at the airport.
Hi, yes. So let me answer that one. So according to an issuance of the PhilHealth for claims, filing, and reimbursement, these are the procedures. Number one, claims application for this benefit shall be filed separately from other COVID-19 claims. While number two, while claim submission is not yet fully automated, manual filing of claims shall be acceptable, and there shall be no direct filing of claims for testing by members except for tests conducted during the period of February 1 to April 14, 2020, and the requirements for claims applications include the following documents. 1, properly accomplished claim form. 2, number 2, certified true copy of case investigation form that is prescribed by DOH. Number 3, official receipts that are required to be directly filed. Receipts are required for directly filed claims for tests conducted during the period of February 1 to April 14. So please take note that all claims for the testing must be filed within 60 calendar days from receipt of the specimen by the testing laboratory. There are separate rules for late filing. Thank you.
Thank you, Ms. Jalin. We have a question from Mr. Vargas. Will flying schools based in Pangasinan be allowed to operate already?
Hi, I will answer the question. So pursuant to IATF Resolution number 35, it is recommended that Pangasinan will not be placed under a community quarantine if similar risk classification prevails by May 14, 2020. So there is a probability of resumption, but this is subject to guidelines or regulations issued by CAAP or Civil Aviation Authority of the Philippines.
Thank you, Bianca. For clarification, we would like to answer again the question of Mr. Noel Sikat. Does PhilHealth covers 100% of hospitalization costs due to COVID-19 related illness?
So pursuant to the latest issuances of PhilHealth actually provides two options: isolation package and COVID test package. Um, Pursuant to these circulars, it is the 100% of the expenses paid for the COVID illness is not covered.
Thank you, Bianca. Mr. Ronnie Pulga asks, under the law, the employer is required to pay the government-mandated contributions of its employees. Since our employee has no earnings, who will going to pay the employee portion? Just to make it clear for our guidance. Thank you.
Erica, I think there has been technical difficulty. Can you repeat the question?
All right. We have another question from Mr. Ronnie Pulga. Under the law, the employer is required to pay the government-mandated contributions of its employees. Since our employees have no earnings, who will going to pay the employees' portion? This is to make sure for our guidance. Thank you.
Hi, I will answer that question. To date, there is no issuance clarifying the guidelines for that as to who will pay for the contribution. But because of that, maybe we can infer that the guidelines prevailing before the ECQ still govern. So it would be still the employees. But may I qualify the question that this answer is always subject to change by any new issuance by the PhilHealth or other government agencies.
Thank you very much, Bianca. We have a question from an anonymous attendee. Under which category may an insurance claims adjusters fall?
Hi, insurance claim adjusters fall under category 3. They are allowed to operate during the GCQ. Thank you.
Thank you, Ms. Jalin. Last question is from an anonymous attendee as well. The nature of our business is manning of OFWs. We deploy seamen on board vessels worldwide. Can you advise if this will fall as an essential business because some of our employees were held up during checkpoints even they have company IDs and certificates of employment? I repeat the question.
Hi, yes.
All right.
So although moneying agencies, although private recruitment agencies are not expressly listed in the DTI circular for essential businesses that are allowed to operate during the ECQ, the POEA Memorandum Circular Number 7, Series of 2020, said that transactions and overseas Filipino workers' arrivals and departures during the ECQ are exempted from the ECQ. Hence, the officers and workers of private recruitment and money agencies are allowed to operate to their offices. Thank you.
Thank you, Ms. Jalin. Due to lack of material time, we will end our question and answer portion. If you have any other questions or if you wish to seek clarification from our panelists, you may email your questions at partners@gsmhlaw.com. Back to you, Mayan.
Thank you, Erica. Thank you, everyone. We would like to apologize if we were not able to accommodate everyone and answer some of the questions you sent us. Again, just like what Erica said, you may email us through the respective email addresses flashed on your screen. Thank you. This webinar will not be complete without Attorney Rodolfo Sanjego, one of the founding partners of the firm, giving his closing remarks. Attorney Sanjego.
I just want to express our firm's gratitude to all of the participants who attended today's webinar. Again, we are presented with a generational challenge to succeed and persist despite the challenges of COVID-19. I just want to repeat that this webinar and the opinions expressed by our panelists are only informational in nature, and the examples that we gave are only for illustration purposes only, for us to render an accurate and actionable opinion on the legal questions that confront your enterprise. Please email us through two email addresses. One is counsel@gsmhlaw.com, or our usual feedback mechanism at partners@gsmhlaw.com. We are also available to conduct face-to-face meeting with you through Zoom or through WebEx. For queries, you can email us through those email addresses. We are also reachable through Facebook. You can connect us through our Facebook page, which is at GSMH Law, and you could ask your questions there. Again, thank you very much for attending this webinar, and please stand by for any future webinars that we will be conducting. Thank you.
Thank you, Attorney Sanzego. Please be informed that in case you miss anything, don't worry, a recorded version of this webinar will be available. Also, please watch out for our announcements in case we will be conducting webinar again. Thank you. Be safe and healthy, everyone. Goodbye.